What's up, guys? Welcome to Bar and Chill. My name is Michael. Today we're talking about service of process, typically a very easy area of the bar exam. Most questions on service of process are layups, but this is also an area where the bar examiners can easily trip you up. They are looking to expose the people who don't have a very clean and organized understanding of the rules, which is why my mantra, after having taken the bar exam twice and passing twice, is you are only as good as what you can bring with you to the bar exam up here. So let's keep it very simple. Without further ado, let's get started. There are three main rules in service of process: the server, the methods of service, and waiver. For server, the person actually giving the complaint and notice of the suit to the defendant must be someone who's at least 18 and a non-party, which literally means it must be an adult who's not the plaintiff. The lawyer for the plaintiff can serve. The lawyer is not a party. Methods of service, the way the server can give notice of the complaint to the defendant, depends on which court we're in. If we're in state court, then any method permitted under state law is valid. Most of the time, the question will tell you that State A follows the federal rules of civil procedure. And if that's the case, then just focus, even though we're in state court, you can simply focus on the federal rules that we'll be discussing shortly. For federal court, okay, the federal rules. People, individuals, can be served in three different ways. The first is personal service, physically handing the complaint and notice to the defendant. This can be done anywhere, including the defendant's workplace. If the server cannot find the defendant, they can do what's called substitute service. 4 elements for substitute service to remember. The server must go to the defendant's usual place of abode, the place where the defendant typically resides. Leave the notice and complaint with someone who's at least 18, who resides in that same place, and somebody who's likely to give it to the defendant. 4 elements, very important to remember. If one of the elements are at issue, the question will make it pretty obvious. And lastly, the server can leave the complaint and notice with the defendant's agent. The question will tell you if this agent is someone who's authorized to receive service on behalf of the defendant, but just note that that would be valid service on the defendant. For entities like LLCs, partnerships, or corporations, the server can leave service of process papers with an officer, an authorized agent, or someone in high placement. If McDonald's is being sued, for example, the server cannot simply leave service of process papers with a cashier. The server must leave it with an officer or someone sufficiently in high placement. The question will make it pretty obvious if it's an issue. Now, an area of service of process that can easily trip you up is that included in the federal rules is any method permitted under state law where the court sits, and any method permitted under state law where service is made. So if we're in federal court and the question tells you we're in state A, and state law permits service of process by leaving papers in the defendant's mailbox. Under the basic rules of federal civil procedure, that is not a permissible way of serving a defendant. However, the federal rules adopt the state law rules for the state where the court sits. So if in federal court we're sitting in a state that permits mailbox service, that is actually a valid service of process even though we're in federal court. It's a little confusing, but the federal rules adopt the state law rules for where the federal court sits. And the same for the state law where service is actually made. So if we're in federal court in state A, defendant is in state B. State B permits mailbox service. The service is done via mailbox in state B. It is actually valid service of process. I think you get the gist, but that's an easy area where the bar exam can trip you up because you're like, hey, mailbox service is not permitted under federal rules, so it's invalid. But be careful. If that is the state law in the state where the federal court sits or the state where service is made, then under the federal rules, it is a valid service of process. Now note, service of process is procedural, meaning if we're in federal court, the federal rules apply, and if we're in state court, the state law rules apply. Like I just said earlier, though, if we're in federal court, the federal rules say the state law rules are permissible methods of service. Now, waiver. The plaintiff can mail a waiver of service to defendant, and defendant can sign and return it. If service of process is waived, defendant is awarded 60 days to answer the complaint instead of the default rules of 21 days. Note, if the defendant decides to waive service of process, this does not waive any defenses except invalid service because they've been served. And that is service of process. Thank you very much for tuning in. I hope I kept it very simple and easy to understand. Remember, the key is just keeping it simple and organized in your head, which means keeping it very simple and organized in your outline. Thanks for watching, and I'll see you in the next video.